This publication and the information provided by the host and/or guest is not meant to serve as a substitute for consultation with an attorney. Specific legal issues, concerns, and conditions always require the advice of appropriate legal professionals. Any communication via this channel does not establish a client-attorney relationship. No confidential or time-sensitive information should be sent or shared.
Nobody's Business, a podcast for all those subjects we've been trained to avoid. Here's your respectfully irreverent host, Keith Shelton.
Well, good evening, everybody. Welcome to the inaugural podcast of It's Nobody's Business. I'm Keith Shelton. I'm your on-air commentator. This is what I would consider a resurrection of an old radio talk show that I used to have back in my early years, my last couple of years of law school, and first year I got out practicing law. And at one time I thought I wanted to be the next Rush Limbaugh, and had a pretty good following. People seemed to enjoy it. People seemed to like the topics we had. I mean, we would talk about news of the day. We'd talk about business. We'd talk about education or the lack of education. We'd talk about finances, the economy. We'd cover a range of topics that would be of interest for business people mainly. And so what I want to do is just, you come to the point where you've experienced a lot, lived enough years, you pretty much don't care what anybody says. You don't fear anybody but God. Well, that's me. So here's my warning to you. You don't like what I've got to say. You got a mouse, you got a clicker, move your mouse, click it, and we'll wave at you on the way out. How about that? Well, joining me is my son, JT Shelton. He'll be my wingman. And the purpose of what we're trying to do as we move forward tonight and in the future podcasts, one of the things we want to do is entertain. We want to educate. We want to inform, make you laugh, challenge you. We want you to expand your horizons. I'll at some point in time, I'll give you a formal brief discussion on the Berean spirit, having a Berean spirit, what that means. It's kind of like the Ronald Reagan phrase, trust but verify. Just because you hear me say it, don't take my word for it. Dig behind what you hear on this show, whether it's from me, with JT, or any of our guests that we're going to have. Do your own research, and we want to hear what you've got to say. So, JT?
Well, thanks for the introduction, Dad. Excited to kick things off with you. Just to repeat what you said, we'd like to be entertaining and informative. A wide variety of topics. I think mostly it's going to be business, some scripture, some education or lack thereof, like you said.
Oh, yeah, we'll be covering spiritual matters. We'll be talking about the Bible. We'll be talking about a lot of subjects.
Well, we
don't fear anybody but God. So just come on along with the journey, and I'm sure you'll find something you will like if you watch long enough.
So just for the viewer's sake, you've got a background and a history in legal. You are an attorney by profession. How long have you been an attorney?
Let's see, graduated in 88, passed the bar in 89. I've been a counselor and advisor ever since. So
what field are you currently in right now?
Well, right now, the main concentration I have is commercial real estate, a little bit of oil and gas. But when I knew when I was going to law school, I didn't play well with others. So I knew I was never going to try to go the route of joining a big law firm and work my way up and play those politics. So when I graduated law school, I hung my shingle out. And what that means to the uninformed is you basically take whatever comes through the door that looks like you can pay a legal bill. And you just hope that your guess is good enough that you don't starve to death. But truly, it is a lot of feast to famine, trying to help people. Nobody goes to see their attorney to tell them, hey, let me tell you how great and wonderful my business partner's treating me.
You're a problem solver. you're a bona fide problem solver. You get paid to solve problems.
Yeah, bona fide problem solver, dealing, most of the time with human misery. So,
well, if you're in the commercial real estate industry right now, that means you're dealing with some pretty wealthy people, right?
Well, over the years, that's what happened. I was blessed that from the time I've hung my shingle out, I pretty much never had a period of time where I didn't have at least one commercial real estate developer or a commercial general contractor as a client, and many times multiples. And over the years, just word of mouth and referrals, that's what my practice gravitated to. And yes, that meant that I was dealing with people who had means. Poor people don't buy and sell commercial real estate. Poor people don't buy and sell oil and gas interests. So by necessity, I also had to get good with business entities, business organizations, employee issues, human resources issues, all the stuff that could land you in hot water with internal matters, external matters. And one of the topics that I became good enough in other people's eyes that I became a nationally recognized speaker, and that was asset protection planning.
So when you say asset protection planning, what does that look like? What is an overview of what asset protection planning looks like?
Well, asset protection planning involves organizing your assets, in some cases segregating your assets, because in today's legal climate, here's the thing, and I've said this for so many years, as any person of means, and I'm going to pause right here and make a point. I was not blessed to have the contacts where I was dealing with, the people who inherited a bunch of assets, a bunch of wealth. Most of the people I've dealt with were blue collar people that started from scratch. Some of them, not well educated, not in a formal sense, but they would build businesses and grow them. Farmers, ranchers, small business people who basically wanted to turn their farm, ranch, small business into bigger farmers, ranchers, and bigger business owners. And over the years, that's who I'm dealing with. I'm dealing with people who were mostly self-made, and they worked hard for what they had. And so my message to them was always, you need to understand that the harder you're working to grow your assets so that one day you can retire and not have to work quite as hard. One day you can plan your business continuation, whatever form that's going to be, to pass things along to your kids, your grandkids. Well, all that means is that the bullseye on your back just grows and grows in direct proportion to how much of your how successful you've been. And that means you are going to be a target of those who weren't willing to work as hard, weren't willing to spend the hours that you did, that didn't want to pay attention to educating themselves in their occupations to be better and improve themselves. And so, in today's climate, especially in Texas, it's what we use the term jackpot jury verdicts, and we'll cover that before we get through today. But asset protection planning it's not a matter if you get sued. It's a matter of when you get sued. And when you get sued, if that's when you decide to take serious any notion of planning and strategizing and organizing, segregating, dividing, any of those tools that are out there, well, I can assure you, you've waited too late. You
And-
need to plan before something happens. And it's not a matter of if, it's a matter of when. It's always a matter of when, not if you've been in business any length of time.
So I've had the pleasure of being around you enough to hear you talk about asset protection planning. Um, you're actually very well versed on the subject, enough so that you get invited across the country to some places. Keith's been invited by several trust companies, colleges, universities to go and talk about asset protection planning. Enough so that when you sit in the seats and you watch people, you see people start to slump down just a little bit. You know, it's not necessarily the most brightest topic in the world, but every now and then you'll hear Keith say something that somebody will sit up real quick and start fiddling around, look for a pen or a piece of paper and start writing some stuff down.
Oh yeah.
So
Oh yeah.
it may
Well,
be it may be a little dry of a topic for some people, but if you've got any type of assets, you're definitely going to want to hear what Keith has to say and take some notes, because he's helped protect a lot of people's assets, and the way he's helped his clients, he's protected them, protected their families, protected them from people who are, you know, as we're going to discuss in a later topic, our legal climate in our country right now is let's see what we can get for nothing. And
yeah. Well, and you know, people need to understand. Here's a hard and fast rule. Let's just hit with hard and fast rules. First one, which is asset protection planning 101, you never need to be out in the stream of commerce in any form of business that you do not have a legal entity standing between you and the public.
what do you
Go ahead.
what do you mean by legal entity?
Well, it could be an LLC, it could be a small, closely held corporation, could be a limited partnership. You definitely do not want to be in this day and age operating in the form of a general partnership. A general partnership by law means that any one partner, as long as the facts and circumstances indicate it, any one partner binds all the other partners, and they're all bound individually. And that means if you had a 5-man partnership and one went rogue on the other 4, that one rogue partner could get everybody else in a world of hurt and their names and their personal assets on the line. That's why you almost never, even though people throw the phrase out there, partnership, you almost never see anybody actually really operating in a general partnership, not in this day and age. And it's been that way for 30 years. Nobody wants to do business in a general partnership. Now, your alternative to either a sole proprietor, which is a person who's doing everything in their own name, or a partnership where it's one or more people coming together to do everything in their own names. Well, everything that's the alternative to either one of those two are legal entities. And like I said, those are corporations, LLCs, limited partnerships, and the most common form is the LLC. And that was because of the adoption of the Model LLC Act in the 1980s. After it was put out there, and the Model LLC Act was adopted in one form or another by almost every state in the country very quickly. And in its original form, it was very good. It was very wealth friendly. And you know, we can talk about some of the intricacies of why that's the case, but just to understand that the LLC was the very common form. Then in 2013, the Model LLC Act committee from the ABA put out some revisions, and those revisions made some changes to portions of the LLC Act that if your state adopted those 2013 revisions, then your state is no longer a very wealth friendly state. Rather, I call them wealth averse states. But like I said, if your state has stuck to the original Model Act, then you are pretty much the LLC is your preferred form, and we can talk after the break of what are some of those features of the LLC that make it that way.
So our producer had fielded a question. It sounds like you just answered it. Is one better than the other? I hear a lot about LLCs, and does every business need to form one? Like for me, before I got into this industry that you're speaking about, I heard a lot about trusts. There's apparently different types of trust. People think, oh, well, if I want to protect things, I need to put things in a trust. So is there one that's better than the other? And if it sounds like you just answered part of the question, that if the Model LLC Act has been enacted in their state, then an LLC is the best. So could you elaborate on that just a little bit?
Yeah. Do you want to do that after the break, or go ahead and start now?
Yeah, we can keep going. Yeah.
Okay. The main thing that makes an LLC a better form over most anything else has to do with the charging order statutes. And people need to understand. Let's go back to some fundamentals. Let's just pause right here and go to some fundamentals. Everybody needs to have an understanding of what happens if you get sued, and you get sued in your name, and someone gets a judgment against you. Now, this is especially important to people because I guarantee you 99 out of 100 people, every 100 listeners and viewers of our podcast, 99 of them have no idea what the creditor exemption statutes say in their respective states. Just like the LLC Act statutes are not mirror images of each other in every state. No, the same can be said for the judgment creditor exemption statutes. And when you talk about, well, let's just say homestead exemption, everybody's heard the phrase homestead exemption, and they think it only has to do with filing to get your taxes on your residence lower. Well, that's one feature. But the exemption statutes differ from state to state, and not all states have their statutes say the same. And what that means is when somebody gets a judgment against you, you are allowed to exempt certain things. Now, I'll quote you Mississippi's. $10,000 of personal assets and homestead up to the value, the equitable value of $75,000 for an individual and $150,000 for a married couple. Or also max at 160 acres. So if you have a $500,000 house sitting on a 800-acre cattle farm in Mississippi, well, 640 of those acres can be attached, and a sale can be had on them. And as far as the residents, if it's a $500,000 house and it's a married couple, so you've got a $150,000 exemption, you got a $200,000 mortgage on it. Well, that's 200 plus 150. That's $350,000 that's exempt. But a judgment creditor can look at that extra $150,000 of equity, and they can force the sale of your home. based on the description I gave. And so people have no idea. They have no idea how exposed their personal assets are to creditors.
Yeah,
Like
it
I
sounds
said,
like I don't want to own any property in Mississippi.
well, Mississippi's better than some. Arkansas is worse than Mississippi.
What's the deal with Arkansas?
Well, the Arkansas Constitution, I'm quoting this from a while back, the Arkansas Constitution limits protected assets at $500.
Is that Amendment 79 property tax relief?
JT, I don't know.
Okay. I was trying to see if I could find a
I haven't
quick article on
studied
it.
Yeah, I haven't studied the exemption statute
Well,
in Arkansas in a while.
We're
but I
we're
do
in
know
Texas.
that there was some controversy, and the Arkansas Attorney General basically answered some questions about life insurance proceeds, and he just simply referred to, it doesn't matter what statutes get adopted. If you don't change the Arkansas Constitution controls. And the Arkansas Constitution, at the time I read that Attorney General opinion, simply referred to the constitutional provision that said exempt personal property in Arkansas is set at $500.
Okay.
And there are other reasons why Arkansas is a very wealth averse state. Arkansas is not a wealth friendly state at all, and we'll cover that when we go into more detail about the LLC statutes. But yeah, I mean, the bottom line is every person would help themselves by knowing what the exemption statutes, creditor exemption statutes, say in your respective state. Now, we just got a note from somebody that said, "What about Texas in comparison?" All right, Texas has unlimited homestead, which means you can have a $30 million house. And a creditor cannot take a personal residence if it is your homestead in Texas. But what if that personal residence is sitting on 1,000 acres of farmland?
Mm-hmm.
Well, in Texas, like Mississippi, it has a acreage volume limit of 200 acres. Mississippi's was 160. Texas is 200. So even though the house cannot be attached, the house has to be sitting within the 200 acres that you want to claim as exempt. And then everything that's outside of that, it can be attached, and a sheriff's sale can be had. And here's the thing people need to understand. At a sheriff's sale, your creditor can literally show up and bid in on your assets. And that's going to be important, when we talk about the charging order statutes and why it's important that the LLC statutes provide for charging order statutes as opposed to most states' corporate law, because charging orders, the protections afforded members of corporations, members of LLCs is not afforded in almost every state to someone who chose to do business as a corporation instead of an LLC. In other words, let's stick to some basics. Somebody gets a judgment against you, all of your assets are subject to examination. And here's what's going to happen. You're going to be served, if somebody gets a judgment against you, you're going to be served with what are known as judgment debtor interrogatories. You're going to be served with what are known as judgment debtor request for production. And you're going to be noticed at some point in time for a judgment debtor deposition. And the interrogatories are going to ask you some very simple things. Give me, identify and describe every personal asset you own that has a value of more than, say, $25. Identify and describe all real estate that you own. Identify and describe all of your bank accounts, all of your trading accounts, all of your CDs. Every asset you own is subject to examination. Now, what you get to do is, like I said, the exemption statutes come into play, and you get to decide in Mississippi, $10,000 worth of personal property. Now, there are also some additional standard things, like you get to keep one TV, one car, one lawnmower, things like that. Okay, that's built into the statute. But then the total value of everything that's exempt personal property wise is limited to $10,000. So all your bank accounts, all your trading accounts at Charles Schwab or Merrill Lynch or whoever, all that is subject to attachment. And unless it fit in that $10,000 value, that asset can wind up having your name removed from it and the name of your creditor put on it. So that's how it works. When it comes to real estate, like I said, you get to say, here's my homestead, and I want the first 150. If I'm a married couple, I want the first $150,000 out of the sale of it, over and above any mortgage. If you had a $200,000 mortgage, using the example of the $500,000 house, if you had a $200,000 mortgage on it, then I'm actually able to save $150,000 of it after the bank is paid. But then the house still can be sold to my creditor, and I get credit against that judgment for the $150,000 that was over and above what I could protect under the exemption statute. Now, if everything fits under the $150,000, then an attorney's not likely to even attempt to seize your residence and force the sale. But let me assure you, in Mississippi, there are a lot of homes that are, well over $500,000. Some of them approaching $1 million. You got so many of those big Delta farms that are well in excess of 160 acres. So
we used to, when I was going to school in Cleveland at Delta State, we used to fly over towards the river a lot from the Cleveland airport. And we would always fly over and look at Gordon Freeman's house. And just to think all that beautiful, beautiful land there, Gordon Freeman never got sued. He only had so much protection under exemption laws.
Yeah.
Well, so knowing your state's creditor exemption statutes is one tiny little facet into what asset protection is.
Knowing those statutes gives you your starting point.
Mm-hmm.
There's a lot more work to be done.
Yeah.
That's where I'm starts, so that you have a real appreciation for what can happen to you if you don't plan and you don't prepare.
So that's just one step you can take. What are some other things? What are some things that you do with your clients right out of the gate? When they call you and they say, "Hey Keith, I'm starting a business. What's something I need to do?" And in my mind, and before coming into this industry, the first thing was I need to go on the Secretary of State's website and register my business. True or false? Is that the end all be all? What do you do when someone says, "Keith, I'm starting a business. I need to set up a business, and I want you to help me do that in a way that protects me"?
Well, the first thing you better do is find somebody that they can trust as an advisor, that can talk about these kinds of things, and that you can have a lot of confidence in, that they've got enough experience, they've researched the subjects enough that they can speak on it from many different angles and at many different levels. For example, if I was a resident of the state of Arkansas, I've already told you Arkansas is a terrible, terrible state now. Since about 2021, when they adopted the 2013 revisions to the Model LLC Act, they actually, they really kicked in the head, well, I won't say kicked them in the head, but they basically pointed a big old cannon at every wealthy person in the state of Arkansas. So if I were dealing with somebody in Arkansas, I say, okay, you chose to live in Arkansas. Let me assure you, I love the state of Arkansas.
Beautiful place.
It's a great.
They don't
place.
call it what is the beautiful state?
The natural state.
The natural state. Sorry.
Yeah.
You can tell I'm not from Arkansas.
Yeah, I love Arkansas. I've lived there before, as a matter of fact. But what I would do is, if I was a resident of Arkansas, I would go to one of the wealth-friendly states that have wealth-friendly LLC laws, and I would form my LLC in that foreign state. And my preferred state right now, my preferred two states is Nevada and Wyoming. And then what I'm going to do for my Arkansas business, I would bring that Wyoming LLC back into Arkansas and register it as a foreign entity. Because what I'm doing, even though, that's the great thing about living in the United States, we have the full faith and credit of the U.S. Constitution, which says I can do business in any of the 50 states and territories. Okay. Well, the same applies to legal entities. They are considered persons, even though they can't vote for president. They can do everything else that you and I can do. And so as a legal person, I can have a Wyoming LLC, and as long as I am a good corporate citizen, I can come back to the state of Arkansas, and I can operate and run a business in the state of Arkansas. I will be doing it as a foreign LLC in Arkansas, but that means that under the civil laws, I'm bound by Arkansas, but under the corporate laws, I'm bound by the state of Wyoming.
I hope that answers your question, Hannah. She had that exact question. Do I have to register in the state where I reside, or can I put my LLC in a more wealth-friendly state? So yeah, it was perfect. You answered that question. So
okay, I'm glad somebody saw that. I didn't.
Yeah, I posted on the screen for just a minute, but it sounds like you answered it perfectly.
Well, when we cover the subject of what exactly did Arkansas wasn't the only one. Montana was another that adopted. They didn't adopt the 2013 revisions completely, but they almost did. And so Montana, which used to be a wealth-friendly conservative state, I wouldn't have any. I have no problem doing business in Wyoming, but I'm sorry, Montana. I just wouldn't be doing business in Montana in a Montana LLC.
So let's say you've been hired to take care of someone's business. You've got them set up in the right state. Is registering the state all you have to do?
Well, here's the thing you need to understand. It's not just a single LLC. You have to look at what somebody's doing with their business says. Many people, after they've been out in the world for any length of time, they're usually doing more than one thing. And so,
for instance, you're in commercial.
Not only thinking in terms of putting something between you and the public, what about putting lines of demarcation between your assets? For example, let's take a typical ranch. Let's take a typical large farm out in West Texas. Let's say 8,000 acres. Take a same thing in the Mississippi Delta, 5,000 acres of cotton land. All right. The dirt itself is not likely to draw attention. It's not likely to incur exposure to civil liability. However, the farming operations very much are exposed to civil liability. You got those big tractors pulling heavy equipment, running up and down the highways. People, the farm workers moving the equipment from one field to the next. Some of them, running implements with leaky hydraulic hoses, and they fold everything up and they start going down the road. And before they get 3 or 4 miles, one side starts, losing that hydraulic fluid, and that thing starts laying down. And next thing you know, they've taken out 3 cars that just were trying to go down the road in the other direction. Well, guess what? You're not going to have enough insurance. Well, let's go back to basics. Let's say that's in the name of Johnny Paul Rodriguez. And Johnny Paul Rodriguez owns the tractor. He owns the farming operations. He owns the land. Everything is in his name. Why? Because that's the way his daddy did it. That's the way his granddaddy did it. And that's the way his granddaddy's daddy did it. So that's the way Johnny Paul Rodriguez has everything set up for him. So one of those farm hands, playing his boom box, paying attention to his cell phone instead of watching what's happening, with the road and what's happening to the equipment behind him. He just caused a major accident. You got fatalities involved there. There's not going to be enough insurance. All right. So what's the situation? 100% of everything Johnny Paul Rodriguez is exposed. What is he able to protect? In Texas, he can protect his residence that he uses for homestead up to an unlimited value. But his acreage is limited to 200.
And he's got 4,000 acres of farmland. That's his livelihood. It's
the goose that's laying the golden egg.
Mm-hmm.
Without the dirt, you have no farming operation. Without no farming operation, you have no income. Okay? So, first thing he should have done is formed an LLC. Mm-hmm. Well, should he have formed one LLC?
Probably multiple, because
I would say you're right.
He's got value in his real estate. He's got value in his equipment, but he's got liability in his equipment and operations. There's no liability in his real estate.
Here we're talking about, where does his greatest exposure to civil liability lie? Mm-hmm. It lies in his farming operation. Mm-hmm. Okay, like I said, that dirt isn't likely to jump up and trip somebody. Mm-hmm. That dirt isn't likely to jump up and run out and pull out in front of somebody in an intersection. Okay, the dirt is the least. The dirt is what creates the least amount of exposure to the public. So put the land in either an LLC or a trust, or an LLC that's owned by a trust, and we can talk about all the advantages of that later. Right now, we're just talking about theories and concepts of asset protection planning. But the farming operation needs to have its own LLC. One other thing, what about the equipment? Should the equipment be owned by the farming operation?
I know the answer to this, but
well, what's the obvious question? The obvious question is, what happens when the farming operation? It's not a matter of if; it's a matter of when the farming operation gets sued. Mm-hmm. If it's in an LLC, that's as far as it can go. It can't go any further, provided the person does what they're supposed to do in a corporate sense, so that the piercing of the veil does not occur. Okay, assuming that's all good. The liability goes to the door of that farming operation LLC, and that's as far as it can go. But what did we just talk about? Everything that farming operation owns stands in for the liability that is going to come against it. Now, here's something you need to understand. There are no exemption statutes that afford protection to legal entities. In other words, where individuals are given the exemption statutes for personal protection, there are no similar protections for legal entities. In other words, if an LLC gets sued, or a corporation gets sued, or a limited partnership gets sued, 100% of whatever that LLC or corporation or limited partnership owns stands in as a potential payor of the whatever the liability turns out to be. So let me go back and ask the question again. Should the farming operation, which is hiring the workers, paying the employees, buying the fertilizer, buying the fuel, should that farming operation also own those $1 million combines, those $600,000 tractors?
No, because if they ever get sued, they're going to lose not only the equipment that makes them the money, but they're going to go after the assets that the operations company owns.
Exactly.
Keith has gone as far in some companies that I've been with him, working with him on, where, we have one company that's in operations, and their operations are risky. Their operations can kill people. And so what they've done,
marijuana growing and production,
oil and gas.
Oil and gas, yeah.
He set it up.
Trucking, whatever.
Mm-hmm. He set it up to where you had an operations company, and the operations company, all it did was pay for operation costs, paid employees, paid for fuel, paid for things like that. And then he had another company set up that owned the equipment. Now, what that company did is it leased the equipment to the operations company. So if someone ever hit up the if something happened where that equipment killed somebody,
when something happened to the
when something happened, not if, when something happened, they could only go after the assets. They could only go after the assets of, I don't know, that might have been operator error there. I don't know if that was the equipment's fault. If it ever happened, they would get the assets of the equipment company, because operations company didn't own that equipment. They leased it. And it just depends. Certainly depends on the situation and who was at fault, things like that. But
I mean, you go look at some of
it adds a layer of protection to your companies to.
Well, what you've done is you've
segregate your assets.
You've segregated assets, and the segregation of assets in multiple LLCs is, it goes along common sense lines. In other words, would you want your LLC that operates a grocery store to also own a bunch of timberland 10 miles outside of town? Well, you've got an ongoing business that could be subject to lawsuits from customers, lawsuits from people passing in front of the store, employee issues, all kind of things. And then you've got 400 acres of timberland 20 miles out of town that's basically doing nothing but seeing the sunrise every day. Why would you have that 400 acres of timberland standing in for the liabilities of an operating, ongoing grocery store business? That doesn't make sense. But do you see those kinds of situations? Yeah, we see them all the time. And it's simply because people haven't thought about these type of things. Because as long as the grocery store LLC is set up right and it's maintained, you do what you're supposed to do, and we can talk about that later. You do what you're supposed to do so that the integrity of the LLC will always be respected. And then you put that timberland in a separate LLC, and you make sure your books are right, you operate it, you identify it, you make sure you respect the integrity of that LLC. Just because you own both of them does not mean that timberland then will have to stand in for any liability that could come against that grocery store operation. So that's just an example of segregation is one of the things you think about, and what you segregate and how you segregate it simply just needs to follow lines that make sense. In other words, let me give you another one. An oil and gas service company, a company that specializes in servicing oil and gas, doing workovers, pumping trucks, stuff like. Plenty of employees running big equipment up and down the highways. Would you want your oil and gas service company to own a bunch of rental property where you got triple net leases and all that real estate, all it's doing is sitting there earning income? Well, we call that mailbox money.
Yep.
We call that mailbox money. You go to the mailbox once a month, and just by owning that income producing property, that's the extent of the work you have to do. Go to the mailbox, pull your check out, get it in the bank. That's pretty much it on a triple net lease. Why would you let your oil field services company that has high exposure, why would you want it to hold the assets of nothing but mailbox money assets?
Yeah, don't think you're going to go form one LLC that's going to be a catch-all for everything you do in life.
No.
It's like we posted on screen. Your assets need to be segregated depending on the scale of your business and your business operations liability.
And the number of LLCs you should have should be thought out, planned, and don't be afraid to have more than one. Just because you're going to have the expense of keeping up with multiple accounting books and things like that. Let me assure you something. All of you business people who are out there, you pay the premiums for insurance.
Mm-hmm.
You do it every year. Well, you need to think in terms of, if I've got to pay an accountant to keep up with 2 sets of books as opposed to one, just put it in your mind. That's just more insurance you're buying, because that's really what you're doing. Because if you don't pay for that, you might find that, like I said, it's not a matter of if, it's a matter of when. And when it's happened, that's too late to start trying to find remedies. Okay.
Well, I think that's a good point for a break from show an ad from our sponsor, and when we come back, we can continue and talk a little bit more about, you were discussing keeping 2 sets of books. Well, some people out here don't know what that means, so maybe we can talk a little bit about that. But for right now, we're going to go to a quick ad from our sponsor, and we'll be right back.
Now, I want to say this. We'd like to say howdy to another of our fine sponsors, the Rainbow Brick Company, from right there on the main drag in Kittiquay, Texas. And we thank Mr. and Mrs. Premert for making our podcast this evening possible. Yep, Roger and Earlene developed a process a number of years back where they could bleach that deep red out of that red sand and rock there at their quarry located right there outside of town, using a special formulation of Clorox bleach and a secret ingredient. And then they can infuse that clay with that bleached sand and rock and add back any color of the rainbow of your choosing. Custom bricks for any of your building needs of the color of your choice. Go by and see Roger and Earlene at their offices and sales showroom. They'll be glad to see you and help you with your next custom brick purchases right there on Deer Park Road in the heart of the big old metroplex of Kittiquay, Texas.
Where'd you find this outfit, Keith?
Well, it's just, Mom's been spending time up there at Caprock Canyon State Park painting. And, you run into neighbors and you see businesses going. And I knew we were going to start this podcast. So I just stopped in one day and said, hey, I got a great idea. How would you like to help sponsor a great idea? So
the process looks like it's rocket science.
What can I say? They're successful going business right there in the big metroplex,
Kittiquay, Texas.
Yep.
In case some of y'all don't know, that's in deep West Texas.
deep West Texas.
So,
all right, where are we going next, son? What are we going to talk about? We talked about some states are better than others. You need to understand. Listeners need to understand. Not all LLCs are the same. And the reason they're not all the same is based on where they are domiciled. Not all states have the same set of LLC laws. And it makes a difference. You have wealth-friendly states and you have what I call wealth-averse states. And the original thinking, and we might as well go ahead and talk about the charging order statute, because this is one of the features that really made the LLC form of doing business the best for small business people trying to grow their assets, trying to grow their wealth. And this is basically what it says. Let's say, for example, you and I and Mom, we're 3 people. We negotiated with each other. We're going to form an LLC. We're going to form a corporation, and we're going to go and do this particular business operation. So we call it JT Sonar and Key LLC. Inc., because I'm going to give you the corporate example first. And our business, we kick it off. I'm doing what I bargained to do. You're doing what you bargained to do. Mom's doing what she bargained to do. So we're all happy. Well, you, for example, you get involved in a bad car wreck. Okay. Well, as soon as you're involved in that car wreck, guess what? Your name's mud. You're going to get sued. Now, whether or not the corporation gets sued, that's a whole nother question. But what we're talking about right now is where that's not an issue. The fact is you got sued. All right. Now, if that person who you injured is successful in getting a judgment against you, and you don't have enough insurance to cover the judgment, here's what can happen. They will do like I said before. They will serve you with judgment debtor interrogatories. They will serve you with judgment debtor request for production. And after they get all that back to them, and you're bound by the rules of civil procedure, you only got so much time to turn that in to your judgment creditor. And you're under oath. You're going to answer all the questions under oath. You're going to be subject to penalties of perjury if you lie, try to hide something, or you conveniently try to forget something. Okay. Well, once all that paperwork came back in, they're going to schedule you for what's called a judgment debtor deposition. And they're going to put you under oath directly in front of a court reporter. And if you don't act just right, they're going to reset that thing for you being in front of a judge. And you're going to have to answer those questions in front of a judge. What they're going to ask you in person is about all those assets you disclosed that you had when you answered your answers to judgment debtor interrogatories, and when you produced all your records like checking accounts, CDs, bank accounts, trading accounts, all that, everything that you own, have titles to, like all the vehicles you have ownership of, you're going to be required to produce certificates of title. All that's going to be disclosed. And then they're going to put you under oath in person and take your deposition. And they're going to ask you to verify all of that. Well, one of the things you're going to have to disclose to them is that you are a 1/3 owner of our little corporation. And, once insurance has paid whatever it was going to pay on the judgment, well, they're out of it. You're left there by yourself. Okay. And so all your assets, except for what are exempt, that you declare as exempt, they get to start going after. They get to engage what is known as a sheriff's sale. In other words, those assets can be attached, legally attached by court order, handed over to the sheriff of your county, and the sheriff will conduct what's known as a sheriff's sale. And all of that is sold to the highest bidder. Well, guess who gets to show up? Your creditor.
Mm-hmm.
What can happen is, at the end of the day, me and your mama, who negotiated to be in business with you, wake up one day and we find out we're in business with Mr. Jimmy John Jones, who we know nothing about, who knows nothing whatsoever about our business. You are out. You have no legal asset in that corporation anymore, and no incentive to continue to help me and your mama make that company profitable. And here we are with a 1/3 owner that's going to do nothing but sit there and wait for us to make money and have to hand a third of it over to this person. Okay.
Mm-hmm.
Well, that's not what we bargained for. That is not what we bargained for. So people need to understand corporate shares are subject to creditors in almost every state. In a minute, I'll tell you the one state that I know of where the state legislature in that particular state thought that the LLC laws were so good that they went back and made similar provisions regarding charging orders for small, closely held corporations in that state. Okay.
Mm-hmm.
But let's stick to where we're going. Now we have, instead of us forming a corporation, me and you and your mama formed a small, closely held LLC. And under the original Model Act, your creditor, same thing happens. You're involved in the accident. I'm not involved in it. Your mama wasn't involved in it. It wasn't on company business. You weren't furthering the company business purposes. It's all you. You're the one that got sued. You're the one that got served with summons and process, and the judge owns you. Okay?
Mm-hmm.
Now, under the charging order statute, your creditor who got the judgment against you, the process plays out the exact same. You, under oath, will have to disclose that you own 1/3 of this LLC, but it's an LLC, not a corporation. And under the charging order statutes, here's what happens. When they find out that you own 1/3 of that LLC, they get to go and get what's called a charging order. And that charging order basically says this, and it's issued by the court, same court that awarded the judgment, will award that judgment creditor this charging order. And it basically says, look, Mr. Corporate Secretary, Mr. LLC Secretary, JT is a judgment debtor in this suit. And the judgment is for X hundred thousands of dollars, X millions of dollars, or whatever. And you are directed to pay anything that would have otherwise come out of that LLC to JT. You are directed to pay it over to JT's judgment creditor. Let's call him Mr. Jones.
As in, if the company was making profit and the company was going to be distributing funds, anything that was supposed to come to me was going to go now to whoever won the lawsuit.
Right. The charging order under most statutes, the way they're written, they simply say that he is entitled to the economic benefit that you had. He is not entitled to your ownership. In other words, you could never have your 1/3 ownership of the LLC taken away from you. Okay?
Mm-hmm.
Which was the exact opposite if it were a corporation. They could literally take your 1/3 ownership, which has multiple ripple effects. Like I said, when we were describing it, me and your mama wake up one day and we're in business with somebody we've never heard of. Don't know, have no idea what they intend to do. How much are they going to contribute to the business? Well, that can't happen under the Model LLC Act the way it was originally written. Okay? Now, here's what's going to happen. And this is why you need to understand this. Never form a member-managed LLC. You always want to form a manager-managed LLC. There's a strategic reason for that. Okay? But the bottom line is you can never have your ownership in that LLC taken away. All right? Now, you're not going to get the money from it. But then again, if you're not a manager, you have no decision making. All the decision making is up to me and mama. Well, what if we decide, as long as this is standing out there, we decide there's not going to be any distributions? Let's say that LLC made $900,000. You would have gotten 300. I would have gotten 300. Mama would have gotten 300. But we're not going to make any distributions.
Mm-hmm.
What's going to happen is because the LLC made $900,000, each one of us get a K1 for $300,000. We're going to have to pay taxes on $300,000, even though we didn't get it.
Mm-hmm.
But your K1 went to who?
The creditor.
The creditor. Do you think that was something the creditor bargained for?
Mm-mm. He said, well, hold on now. I haven't even made any money. Why am I paying taxes on this?
Why am I paying taxes on $300,000 I never received?
Give me $300,000 and then I'll pay it. Oh, well, sorry. We're not making contributions.
We're not making distributions.
Distributions, yeah.
Yeah. And see, because you're not a manager anymore, you're out of the picture.
I can't tell you to give them $300,000.
No, because the LLC was written so that only managers decide when and if distributions will ever be made.
What viewers probably didn't understand is when you set up an LLC, just going to the website and setting up an LLC through the website does you no good. It ain't worth it's about as worth as much as the paper it's printed on.
Yeah.
You have to set up an LLC with a set of books, and that's when Keith was talking about, a CPA managing 2 books. Each LLC needs to have its own book. It has an operating agreement, it has membership certificates, it has bylaws, things in it things that make
things that create the evidence that LLC was operated as an LLC and not simply as an alter ego of its owners, or that the owners were using the LLC as an alter ego of themselves. That's what allows for the piercing of the corporate veil. You're shooting yourself in the foot if you don't deal with, good business practices when it comes to maintaining good because the books is all you have for the evidence. It's the evidence that you've been respecting your LLC. Now, you got to understand this, and I know it may seem like we're rambling, and we are, because it's not a topic you can cover in 15 minutes. There's a lot of nuances to it. But here's what's going to happen, and we're getting off of the corporate. The charging order statute portion. We're talking about liability that came against the LLC. And the possibility that liability that came against the LLC may be able to go through that LLC to get to you personally. Well, if that's ever possible, then you wasted your time setting up the LLC. Because remember what we said. What was Asset Protection 101? Put a legal entity between you and the public. Well, if that legal entity is nothing but a wisp of a vapor in the eyes of the law, then it's really not going to be given any credibility, and the judge is going to allow what's known in legal jargon as the piercing of the corporate veil. In other words, it's not real. It's nothing but a veil that somebody sees, but they see you on the other side of it, because that's all it is. It's just a wispy veil, because the LLC has no substance. And the theory works for the same for corporations, limited partnerships, or whatever. You've got to have enough evidence that integrity of that legal entity has been respected by you, because here's what's going to happen. You're in court, and the injured party's on one side of the courtroom, you're on the other side of the courtroom, and the judge is going to tell you this. Mr. LLC owner, these people over here on this side of the room, they want me to allow the piercing of your corporate veil. They want me to allow them to go through your LLC to get to you and your personal assets. Now, here's my question to you. Why should I respect your LLC when, after I've looked at all the circumstances involved in that LLC and your operation of it and your ownership of it, it's obvious to me that you didn't respect your LLC? And folks, I'm telling you, when a judge reaches that conclusion, he's going to find a way to let those people get to your assets. So what's the question? Mr. Business Owner, why should I respect the integrity of your LLC when it's obvious to me you didn't respect the integrity of your LLC? Now, what are the things that can cause problems? Commingling money, paying personal debts with company assets, paying company assets with personal money. Y'all are aware of the fact that almost every state in the country adopted a statute that says an operating agreement for an LLC is basically in the legal jargon, it's the counterpart of a set of corporate bylaws. Okay, where a corporation would have bylaws, LLCs have operating agreements. Now, here's my question. Are you aware of the fact that most state statutes explicitly say you're not required to have an operating agreement in writing? Did you know that? Yeah, that's the case. And you know who you're going to very likely hear that from? Your CPA. An attorney wannabe CPA is going to tell you, well, you don't even have to have an operating agreement.
You can't tell if Keith's had run-ins with CPAs before, guys, can you?
Was that obvious? I didn't mean to make that obvious. All right. But let's get to the point.
Yeah.
The point is you don't have to have a written operating agreement in almost every state in the country. But is it wise not to have a written operating agreement? Because you got to remember, what is an operating agreement? The operative word there is agreement. In a multi-member LLC, agreement means a meeting of the minds on quite a number of possible things that can involve an LLC. And if you don't have a written operating agreement, where's your evidence that you and your two other members actually came to a meeting of the minds? Where's the evidence? It's not going to be in writing because y'all decided not to adopt a written operating agreement. So where's it going to come from? You know what's going to happen? They're going to take each one of your depositions. Somebody trying to pierce your corporate veil.
Mm-hmm.
And when he gets when the attorney gets 3 different answers to the same question, that's something material to the ownership, operation, or management of an LLC, and y'all can't get together on what y'all thought y'all were agreeing to, well, that's strike 1. Then he's going to ask you another question. He gets 3 different answers. That's strike 2. He asks you another question about something else that's really important to how to run an LLC. He gets 3 different answers again. That's strike 4. I mean, my goodness. At some point in time, it's going to be quite easy to go right back into court and say, Judge, these people didn't have a clue what they agreed to. They had no agreement. Therefore, they have no operating agreement. Therefore, that's the evidence that they've just been running this thing by the seat of the britches. Therefore, this LLC is nothing but the alter ego of these 3 owners, and these 3 owners are nothing but the alter ego of this LLC. Therefore, Judge, I'm asking you to allow us to pierce the corporate veil. And that's the kind of evidence that is fatal to your LLC standing between you and the public. Now, here's my question. Why did you bother? Why did you spend the money to register it, and you didn't do enough to even create a good initial set of books? I got a client. It's a real estate holding company, buying and selling real estate. They're probably on their 12th 3-ring binder volume. 12 volumes of 3-ring binders. Now,
compare that to 1 sheet of paper you get from the Secretary of State's office.
Yeah, I mean, let me tell you what will happen if something happens and you try to throw up an LLC 5 years after it was registered. Yeah, you filed your annual reports. Okay, I'll give you that. You filed your annual reports. It shows it's in good standing. But when I ask you for your set of corporate books, and all you can hand me is your original articles of organization or certificate of formation, as it's called in Texas. The document is the same. It's just it goes by different names depending on the state. But that's all you can hand to me is something that you got from the Secretary of State's office 4 years earlier. You know what's going to happen? I'm going to start growing hair on the back of my hand. I'm going to start growing fangs. I'm going to start drooling. You know why? Because I know there's a high degree of likelihood I'm going to be able to go after every asset you own, because you didn't have enough good sense to know how to create the evidence that showed that you respected the integrity of what you did 4 years earlier. Okay?
Okay. So
that's the piercing of the veil thing. Don't commingle funds. Don't pay personal debts with company money. Don't pay company debts with personal money. You can do it, but do it correctly. Loan it to the company. It's perfectly okay for you to loan your LLC money. It's perfectly okay for your LLC to loan you money, but do it in the form of a loan and then pay whatever bill that needs to be paid.
Yeah.
Don't just create the evidence that's going to make it so clear and obvious that one was the alter ego of the other. That means they're going to be treated as the same, and that means that it was worthless, and your personal assets that you thought you were protecting by throwing up that LLC in front of you are exposed.
Yeah, it's not a matter of if, it's a matter of when.
It's not a matter of if, it's a matter of when.
Well, Key, we spent a good amount of time talking about why it's important for asset protection planning, and I definitely think we could go on for hours, and we might even expand a little more if we get some more questions or requests from anybody for help or information. Be glad to give it. We've talked a lot about getting sued. It's not a matter of if, it's a matter of when. So maybe now is as good a time as any to kind of shift here, but let's talk a little bit about the legal climate that we're in right now. We see a lot right now of people, everybody's mentality is getting something for nothing.
Well, JT, here's the thing. All of our listeners, I guarantee you, 99 out of 100 of our listeners or viewers have already suffered in the last 3 years outrageous increases in their liability insurance, whether it's homeowners insurance, auto insurance, or business liability insurance.
Oh yeah.
I guarantee you.
My home insurance last two years ago, I bought my house, $1,700 premium. This year, $2,500. Car insurance, $180 for 2 cars, brand new. This year, it's up to $350, $400. I had to shop around just to get it down.
All right. Well, here's what I'm going to tell you. Years ago, back when we used to live in Mississippi and I was practicing Mississippi, Mississippi was known as the land of jackpot justice, runaway jury verdicts. Well, we can show you what's happened in the state of Texas as wealth friendly. I'm sorry. For all the wealth there is in the state of Texas is not a very wealth friendly state when it comes to its civil litigation system. I believe we have some examples, don't we?
Yeah. I've got a judgment here. This is in Nueces County, so this is all public record, right? This is something people can pull up.
Yeah, if they're willing to go to the courthouse. I mean, you probably won't be able to pull up the actual jury instructions. The jury verdict, unless you were a lawyer or something. But you could actually go to the court file and ask to see the court file, and the judgments will be found. And yes, these are real jury judgments.
So what is this case?
Well, let's see. Go back to the first page and let me see which one this is. Is this?
This is the sports bar.
I know what county.
Nueces County.
Nueces County. This, I believe, is the $1 billion.
$301 billion.
Yeah. Okay. This was a combination of punitive damages and actual damages, but punitive damages are limited by a legal theory that involves the U.S. Constitution. In other words, a jury can award for punitive damages, and you need to understand the difference between punitive damages and actual damages. Punitive damages are those damages that are awarded as a matter of principle, because our society believes that somebody's conduct which caused the injury was so outrageous, so egregious that it shocks the conscience, and it needs to be punished. The person needs to be punished for having been so careless, so reckless, with such disregard, so outrageous, so egregious. Then here's how we're going to punish them. Those are punitive damages. Okay. Those are capped, and I'm not going to go into trying to explain the mechanism, but they're capped by the U.S. Constitution for cruel and inhuman punishment. I believe that was one. But guess what's not capped? Actual damages. Awarded as actual damages, they are unreviewable depending on the categories. And here's the thing: in the old days, you had to start with the value. Let's say in a wrongful death case, you had to start with the actual way to fix the monetary value of the decedent, so that you could decide, those who are left, those survivors, what is the value that they will no longer have of that person, because you are the one that caused the accident and you killed this person. What was the value of that person's life? Well, they don't even bother starting there anymore. They just go straight to two categories of actual damages, and it's basically fill in the blank. And what that means is loss of consortium and companionship, and past, loss of consortium and companionship, future, and the other one is pain and suffering, mental anguish, past, pain and suffering, mental anguish, future. That's 4 categories, and they're all fill in the blank. and JT, you moving too fast. Stick on the one. Look at those awards. One survivor, $45 million for loss of companionship. Let's see. Wait a minute. Loss of companionship in society in the future. All right, going down. 45 million for the first, 50 million for the second, going down. Mental anguish, past, 50 million. Mental anguish, future, what's that one?
45
million. That's fill in the blank. This one had an additional category of pecuniary loss, 50 million. This total award,
what does pecuniary mean?
Financial.
Care, maintenance, support.
But again, they don't have to put on any proof of that value. It's a fill in the blank. It's like going to the casino.
It was filled in by a jury.
Yeah, it's filled in by the jury.
Yeah.
And like I said, they don't even bother putting on evidence to the economic value of the person that was killed. They just go straight to the sympathy of the jury. Now, can you go and find the total award?
Yeah. So there was
multiple
beneficiaries. And so it was all the same thing, fill in the blank for, how did they come up with, for one person, it was 45 million and another one, it was 100 million. We don't know, obviously, the intricacies of this case or who these people were, what their occupations were, but
we're already talking about amounts of money that are way beyond any amount of insurance we will ever cover for our businesses or ourselves.
So here's the summary, the final question. It was just total what sum of money should be assessed against this company.
No, that's exemplary damage. That's the punitive damages I was talking about. 300 billion in punitive damages. Now, like I said, that would be cut. That would be cut by the principle of the U.S. Constitution. But guess what wouldn't be cut? What would not be cut is the actual numbers that got put in for actual damages. Those numbers would not get cut. You would have to file a motion for a judgment notwithstanding the verdict. And again, it's obvious when you look at this one, you look at the other case you're going to show, this is where we are. It's fill in the blank.
You've got another case. This one is called, let me pull it up.
Yeah, that one was from Reagan County. The numbers weren't quite so mind-boggling. But
this is a drilling company, so it's oil and gas related.
It was a trucking company. It was a trucking company, I believe.
Our producers,
it was a drilling company, and it was one of their trucks that was involved.
One of our producers fielding a question here. What in the world did Billy Beer do wrong? What was the case about? What happened?
Car wreck.
Somebody left a bar drunk and wrecked a car, and they held Billy Beer liable.
Yeah, well, yeah, that particular one was a dram shop case. That's where somebody, the nightclub kept feeding drinks to somebody when they knew or should have known that they had already reached a state of intoxication, and then they didn't prevent the person from leaving under his own direction, operating a vehicle. And so that's what Billy Beer was about. It was it's what's called those type of cases are called dram shop cases, and that's where the bar is held liable if one of their patrons leaves and then goes and gets involved in a serious auto accident, kills somebody or severely injures them. Okay, and that's why the punitive damages appeared in that one, is because they're saying the bar needed to be punished because they were so careless and so reckless in how they didn't pay attention to the drunk guy who left and went and caused mayhem on the roads.
And this is a Texas. That was a Texas case.
Both of these are Texas cases.
That's really interesting. It's like, in my mind, you would think you wouldn't realize that there's actually a duty or, for a bar to care. Like you're a grown man, you do what you want to do, right?
Well, that JT, that is the uninformed public. Dram shop cases have been around for a long, long time.
Okay.
Long time.
I believe you. I learned something new today. I hope I hope the audience did too. All right. Moving right along.
Moving right along, the Reagan County case. This has involved one death, and I believe there were 5 beneficiaries.
So somebody died. Somebody died at a drilling rig. There was an accident at a drilling rig.
They died on the highway. On the highway.
It's good to give an overview of what happened and why this case happened. So
died on the highway, and it involved one death, and the jury determined that the driver of the drilling rig truck that caused the accident was 100% liable. There was no contribution by the victim. So whatever these dollar amounts were, they were 100% assessed against the drilling company. You can see there. All right. At the time of the accident in question, was the driver, acting in the course and scope of his employment with H&P? The jury found yes. Well, what that did was that meant the driver's liable and his employer was liable. At the time of the accident in question, was Albert Barnes on a special mission, otherwise performing services in furtherance of H&P's business. See, it's course and scope is one legal category, and then furtherance of the business of the employer is another category. The answer to both of those questions was yes. So that pretty much sealed the deal. The driver himself got sued. His employer got sued. So now go ahead. Need to close that on the right side there. So there you go. All right. These weren't filled in by typewriter or word processor. These were filled in by hand by the jury. Loss of companion society sustained in the past, $5 million. Loss of companionship in society will sustain in the future, $5 million. Going to the next one. Mental anguish sustained in the past, $5 million. Mental anguish that it will be sustained in the future. This is one beneficiary now, $5 million. That's $20 million for this beneficiary. Well, there were 5 of them. And these questions were answered the exact same for the other 4. This was a $100 million jury verdict. One decedent, $100 million. Do you think they had enough insurance?
I know. Actually, in one of them, they were answering $10 million.
Oh, I missed that one.
Yeah,
I'm sorry. So then that must have been 100. Okay, 120. That was, let's see. That'd be 80 plus 40. That would be 120. That was a $120 million verdict. My bad. I'm glad you caught that. But here's the point. Does anybody have that amount in insurance? The answer is no. So what happens? The insurance company pays policy limits, and then guess who's sitting there left with the rest to deal with? The business owner.
Yeah, I know that driver didn't have $120 million to cash out, and his insurance didn't have $120 million to cash out. That was somebody's business.
No. So here you go. Let's say they had $20 million in insurance. So the $20 million paid. This was a big drilling company in West Texas. So I don't know how much insurance they have, but let's say it's $20 million. So they paid $20 million. That was a $100 million verdict. That meant all the trucks are up for attachment, all the bank accounts, all the drilling rigs, all the workover rigs, all the pipe and stands and bulldozers and track hoes, backhoes, dump trucks, low boys, every asset that company owned would stand in for everything over and above what insurance would pay. Now, here's your real world scenario. That was a real world scenario. That actually happened. That jury verdict's real. That case has already been decided. That was a recent, I think it was in the last 3 years. All right. Let's go back to our example, and let's change the facts a little bit. You got a person who, his dad was a plumber. He learned from his dad. He was a journeyman with his dad. He learned the business. Dad worked for XYZ company. Well, the son didn't want to necessarily take over his dad's position with that company. He wanted to start his own company. So, he worked all day. Mom, she did the books on the kitchen table after she got the kids put to bed at night. And he had one raggedy old pickup truck that he did all his traveling in to all the work sites he had to go to. Well, 20 years later, he's got 40 employees. He's got 10 trucks, 10, work trucks. He's got a couple of backhoes, got one small dozer. Let's see, got tons and tons of, he's got an office building where his plumbing business is located. He's got, 40 workers. So he's probably got 10 office staff. That's 50 employees, depending on their jobs, depending on him to run a good company. So they'll have jobs. So here's what happens. Exact same situation, but he's not going to be carrying $20 million of insurance. Okay. He might carry two, but now here's somebody that pulled himself up by the bootstrap, worked hard all his life. His wife sacrificed raising kids, did 11 o'clock, 12 o'clock at night. She's doing all the books, paying bills at the kitchen table. Okay. So they built a business that was worth a lot. And the same thing happens. One of his drivers was negligent and caused an accident, some severe injuries, possibly a death. And there's a jury verdict. Now you got to understand, the juries are not allowed to know who the defendant really is as far as assets and stuff. They're not allowed to know that at trial. They're supposed to administer justice based on what they think is right for the victims. So it is exactly possible that for this plumbing company that's not nearly as big, not nearly as wealthy as that oil field company was, they could be hit with the exact same jury verdict. Now, here's where asset protection comes into play. Do we all understand that at the end of the day, if that same kind of jury verdict was awarded, that's $120 million of a judgment. Let's say $2 million of that got paid by insurance. Oh, let's be generous. He got a break from his insurance agent. He actually had $5 million of corporate liability. Okay. So $5 million paid on $120 million. That's $115 million unsatisfied. Guess what that judgment creditor gets to do? Come directly against the assets of the LLC. Every asset that LLC owns will stand in to satisfy that judgment.
All the contracts he has to go do work with GCs, all the maintenance contracts he has with existing customers, the building, the equipment, the trucks. If he didn't do his asset planning right, it's all gone.
It's all gone. That's exactly right. Now he still has the LLC. Let's assume he, the LLC's not pierced. But the fact is, all the LLC, the bank accounts, the CDs that, where he had good years and he bought CDs to have some money there for profit sharing for his best employees, let's say, all that's gone. Every bit of that's gone. And that's why I say, how many people in our audience can understand and figure out that you can really be burning up the world, and in the blink of an eye, you could be left being nothing but a Walmart greeter. That's how you get to end your life. That's how you get to spend the last days of your life as a Walmart greeter. Why? Because you didn't plan for what could happen. Now,
what what's your saying? Failure to plan is planning to fail.
Yeah, a failure to plan is planning to fail. Now,
Well,
go ahead.
no, I was just going to say, I think, unless you had something else, I was just going to say, I think that was a great inaugural episode for us. We made a powerful impact in the, I think in the podcast world by showing people, there's a lot of work to do if you're going to be successful in this business. It's not about just doing the business. You've got to think about things outside the box. You got to think about ways to protect you and protect your family, because it's not just about you. It's about those that have sacrificed for you and those that have helped lift you up. Hopefully we were well, entertaining and informative tonight for our inaugural podcast for the Nobody's Business kickoff.
Yeah, well, here's what I'm going to say to wrap up my side of it, JT. It's not rocket science. Usually it's a case of just simply talking to somebody who's seen a lot of the wrong ways to do things and learn from where other people have done things the wrong way and incorporate the things that can help you, help position your assets, help segregate your assets, multiple LLCs, et cetera, et cetera. It's not rocket science. And when you start hearing the principles behind the advice that somebody could give, you go, man, that makes perfect sense. Why didn't I think of that? The fact is, I use this phrase, the widget maker loves making widgets. He does not like worrying about sexual harassment issues. He does not like worrying about payroll. He does not like worrying about, paying bills. He loves making widgets. That's his passion. But the fact is, if you're going to think you're going to be able to make a business out of making widgets, you or somebody under your direction has got to pay attention to the things that, it's like JT said, outside the box of making widgets.
Good deal. Dad, it was a pleasure as always. I can't wait to see what you got for us next time. To our audience, thanks for listening. Appreciate the viewers we've got on tonight. Appreciate the interaction and the questions. If you guys want to shoot us an email, it's nobodiesbusinessmedia@gmail.com. If you wanted to follow up after the show or leave a comment on our YouTube page, we just appreciate the opportunity and look forward to this journey with you guys. Hopefully we got some exciting stuff coming for you next week.
All right. Well, good night, everybody. And we'll see you next time.
Thanks, everybody.